Hello, everyone. I'm Joe Lovell. I appreciate everybody being here today. I am told by my associate Hannah Rivera, who is helping. Fortunately, she's technologically competent, so she's helping guide us through this Zoom conference today. I got to tell you, I'm appearing live. We're myself. You should see my partner Brian Farabough, also Michael Watts, and our arborist John Brown. We are appearing and coming to you today live from the historic El Fidel Hotel in Las Vegas, New Mexico. It's a truly historic hotel that they're remodeling. Michael and Brian and John and I had to scatter out so that we didn't have a feedback problem. And so I'm literally coming to you from an old 1920s era phone booth with a little door and everything to keep out the noise from the lobby. So hopefully you can hear well. Again, we appreciate you all coming. First, a little bit about myself and my firm, then I'm going to introduce Michael Watts. Then we'll talk about the issues that we see in this case. I do see that we have several people who are already clients. I recognize a lot of names and some faces, and for all of you, welcome. You may have heard some of this stuff before. I hope you can bear with us. But for those of you who aren't, we're going to kind of cover how we see the case, the status of this situation, the status of the bill that's out there, and what we are doing and how we are approaching this. So first, I know some of you, several of you, are probably not from New Mexico, and you're coming to us largely from Texas. That's me and my office. My law firm is Lovell, Isern, and Farabough. We're headquartered in Amarillo, Texas, and the way we started early on, very early on, getting involved in this is that I have family and we have friends and acquaintances who have property up there in the Las Vegas area who started calling us before this thing even got anywhere near as big as it did. In any event, my law firm and I, we have handled wildfire cases since 2000. I tried my first wildfire case in 2000, and we've handled fire cases since then. Of course, in Texas, and it's a little different in some ways. It's different than what we're facing here in New Mexico, largely because of the type of terrain, and even more importantly, because we're not dealing in Texas with the U.S. Forest Service. In any event, we have a lot of experience in this, but when this started blowing up and we saw the scale that this was taking on, I knew immediately that this was going to require an army to handle this kind and this scale of litigation. And so I picked up the phone, called my friend Michael Watts, who I've known for years and worked with for years, particularly the last few years. Michael and I worked very, very closely together on a case that ended up having a very good result for our client. Anyway, I've come to highly respect Michael and his law firm, and I trust them. And I also know, not just think, I know they do an excellent job. And Michael also has extensive experience in wildfire cases, particularly on a mass tort level like this, as well as the resources to bring to bear for something like this. So I asked Michael, and we studied this matter for quite a while because, and I'm not going to get into the weeds right now, but just on the surface, this situation has some real complexities from a legal standpoint, primarily to the fact that the United States government will be your defendant. And the United States government, they're different than everybody else, or most government entities are, in that the law gives them what's called sovereign immunity, which means literally the king can do no wrong. And so you, as a basic concept in the United States, you cannot sue a governmental entity unless and only to the extent that the governmental entity gives you permission to sue them. Okay. And so they don't do that lightly. Now, they do have statutes that grant permission, and we'll talk about a little bit of that. One is the Federal Tort Claims Act. Another is in the situation if your claim constitutes a taking of property without just compensation as required by the Constitution. In any event, even on top of that, though, if you're able to fall within or fall outside of sovereign immunity under the Tort Claims Act, there's another concept in there called discretionary function exemption to the Tort Claims Act. And what that says is that even if the government does screw up and cause harm like they did here, you can't sue them if the harm was caused by a discretionary act of the government official or government agency. And that is a very, very broad exemption, which very often results in putting people out of court. Okay, now we're confident that the facts of this particular situation, as they have developed and as we know them so far, give us a crack in that discretionary function armor. And my partner, Brian Farabough, will address that in more detail later. But in any event, and we'll get into this in more detail later, but we see three possible routes to successful recovery for those of you, all of you who've suffered some kind of harm from this fire. One is through the Federal Tort Claims Act, which I was just touching upon. Another, maybe, we're not convinced of this, but theoretically anyway, there may be some claims that might constitute takings, and that is a different route to compensation under the law. And then the third one, which we'll talk quite a bit about, is what we've been calling HR 7721, which is the Hermits Peak Fire Assistance Act. We'll talk about the status of that act, what it means for you, and why it could be, frankly, by far and away the most important route to recovery if it passes the Senate. It has passed the House, but if it passes the Senate. Okay, so now I'm first going to turn it over to Michael, and I gave you a little bit of introduction to Michael, but Michael's firm is Watson Guerra. Their home base is out of San Antonio, but as Michael will tell you in much more detail in just a moment, Michael has, over the last 5 or more years, he's become extensively experienced in massive fire cases like this. He'll tell you about that. And that, like I said, that's one of the reasons I picked up the phone and called him. And that's one of the reasons I'm pleased that he agreed to help us with this. So with that, Michael, would you take over?
Sure. Good morning, everybody, and thank you for getting on a Saturday. I'm Michael Watts. I'm a lawyer from San Antonio, and I'm going to share my screen so I can take you through a PowerPoint that will make sure that I hit all the points that I want, and you'll be able to follow along. So bottom line is that I don't need to tell you what happened. A lot of you lost properties through no fault of your own from one of two fires, the Hermits Peak Fire or the Calf Canyon Fire that merged. And the government is responsible for both of those fires. And the investigations that we've done and that they've done of themselves have revealed that. Here is the footprint of the fire. If you have property inside that footprint, you have a claim. It's approximately 360,000 acres. And the bottom line is we know what happened. We know exactly what happened. And we know when it happened, and we know how the fire spread. We have satellite imagery. And so we'll be able to attribute causation from the standpoint of this fire or that fire for pretty much everybody whose structures were burned. As of June the 21st, the last time I looked at this, it was 341,000 acres. I think it ended up at over 360,000 acres, about 1,000 structures destroyed, another 85 that were damaged. Fortunately, it's finally under control. Bottom line is that there was a prescribed burn that should not have happened given the weather conditions. They tried to fit it in at the end of prescribed burn season during a day where, frankly, there was a pretty high wind, and they call them unexpected winds, but our evidence is that they knew they were coming. They had a prescribed burn that was not following the prescribed burn plan that I'll let Brian talk about in more detail. And then the second fire, the Calf Canyon fire, was a pile burn holdover from January that just remained dormant under the surface and was never put out. And that's also on the government. Big reason we're here is weather. This took place during severe drought conditions. Those severe drought conditions are one of the reasons that this prescribed burn should have never taken place that day. And I could take you through all of the global warming and the La Nina and the weather, but the bottom line is there's people a lot smarter than Michael Watts that knew exactly what the weather conditions were out there. There are computer programs that take all of the different factors like temperature, lack of humidity, and therefore lack of fluids in the woods that make it very much a fire danger. And you know it more as a red flag warning day, which is exactly where it was. And so the bottom line is that the agency, I'm not sure why that's not showing. They tell me my PowerPoint's not showing, so I apologize for that. But anyway, the bottom line is 90% of the agency's burns take place between September and May, and they were running out of time. They were in a blind rush. On April the 15th, they announced they would do it on April the 5th, they announced they would do a prescribed burn on the 6th. And it just wasn't a good idea. Now, that's not going to get us there around discretionary function immunity, and I'll talk about that. But the bottom line is that their own evaluation of what happened, the Forest Service has basically said we screwed up. To their credit, they didn't play hide the ball. Within a week, they said our prescribed burn from last Wednesday was the cause of the Hermits Peak Fire. With that said, we take full responsibility, and with a heavy heart, we're really sorry for what happened. That was within a week. Now, that doesn't mean they have liability, particularly under the Federal Tort Claims Act. And so the political aspect of this became very important. Governor Michelle Lujan Grisham got involved. Both of your U.S. senators got involved. And that has become very important because within a matter of weeks, Senator Heinrich and Senator Lujan introduced the Hermits Peak Fire Assistance Act of 2022. Why is that important? Well, it's important because they understand from bad case law that exists that even when the United States Forest Service starts a wildfire through a prescribed burn that gets out of hand, the courts have said that you can't sue under the Federal Tort Claims Act because of the discretionary function exemption that's in that act. And so there is a thread of cases that we're going to pursue if this bill doesn't pass that says, hey, if you've got a written prescribed burn plan and you don't follow it, that doesn't implicate discretionary function. You exercised your discretionary function in deciding what the plan should be. So Watts isn't allowed to come into court with his clients and complain about what the plan was. But if, on the other hand, you had a prescribed burn plan that you didn't follow, and the failure to follow that plan is the reason the fire occurred, then you've got something that's cognizable in court. And so generally, this is where we are. The U.S. Forest Service came out with a report on June of 2022, where basically they say we're real sorry we messed up, but they say we followed our plan. That is lawyer code word for we're not liable. Now, they're not going to say it because they can't politically sell it, but we've got pretty good evidence that Brian will talk about that'll explain that they are. And the evidence is, in effect, they had an igniter that took the fire to the tow and returned unannounced with a second pass back up the fire line, bringing the fire with them. That was not in the plan. We've got a Freedom of Information Act request. And yeah, hold on just a sec. Let me just stop for a second. They're telling me I'm all screwed up here. Give me a second. So the bottom line is that this prescribed burn was deviated from, got out of control, and was declared a wildfire within hours. Now, other than the fact that I don't know how to share a screen, let me explain to you why you might want to consider our firm to handle this case. Number one, we've got a lot of experience in representing a lot of people at once in tort litigation. It's called mass tort litigation. My experience started with fire cases, a different kind, and that was the Ford Pinto litigation. Back when those cars would get hit in the rear and the fuel tank would get punctured and people would burn alive. That's all I did for the first 5 years of my career. Then I went to GM pickup trucks where the fuel tank was outside the frame rail and they'd get hit in the side and people would burn alive in their pickup trucks. We did Dodge pickup truck fires. Then I got involved and led the nation's litigation involving Firestone tires about 20 years ago. That led to the recall of 17 million tires and the passage of the Tread Act, which is the reason your cars all have that fire inflation pressure notification up on the front console. And so we've really made tires a lot safer. We then got into rollovers and different kinds of medical stuff and formaldehyde after the FEMA put a bunch of formaldehyde emitting woods following Hurricane Katrina. We represent a lot of people, tens of thousands of people at once in these things. In the middle of the FEMA trailers, we had 30,000 people. In the TransUnion credit report cases, we represented 65,000 people. The corn farmer case against Syngenta, 55,000 corn farmers. So I get appointed to lead a lot of these consolidated litigations because I tend to try these first cases in the country. And that's what we're prepared to do on your behalf. As Joe mentioned, over the last 5 years, my career's kind of taken a turn west. And the way that happened was I represent one corporation, and that's Valero. Their general counsel had a son that goes to school with my son, and he knew who I was. And he said, "Hey, will you represent us when we've got disputes?" And I said, "Well, I won't defend you when you hurt people, but I will help you in cases where people hurt you." And so he called me in 2017 and he said, "We've got a situation out north of San Francisco in a place called Benicia, where a lineman for Pacific Gas and Electric shut our power off and it froze up all of our pipes and our refinery was down for 35 days and it cost Valero $105 million. And I was a little reticent about having a guy with a Texas accent representing a Texas oil company against a Northern California utility in a very environmentally conscious area. And so we did a test trial, what's called a mock trial. And we flew out there and we were working on it and learned that everything was okay in terms of how Valero would be treated. But on the second day, the jury really got ticked off at PG&E and I couldn't figure out the difference. And then I opened up the newspaper and it turned out 4 days before they had started the North Bay fires in 2017, and their equipment was being blamed. And I just got transfixed. I went on the lawyer version of Google, we call it Westlaw, and started researching wildfire case law and precedent in California. And I flew up to Alaska to give a speech about how to do mass tort cases to a bunch of trial lawyers up there. And the whole time I was on Westlaw. And 2 days later, when I was in a layover in Denver on the way back home, I called my partner and said, "We're going to open up an office in Northern California." We ended up representing over 2,000 people whose homes burned down in the Tubbs fire in October of 2017. While we were working on those cases, PG&E burned down another town called Paradise. You probably heard of this one. It was the Camp Fire. Burned down 14,000 houses, killed 86 people. So we set up a second office and ended up representing about 14,000 of those folks. And then over the course of the next 4 or 5 years, all of these different fires that are listed on the page up and down the California coast, in Oregon and in Washington, Colorado, and now more recently in New Mexico. I feel a little bit like Bill Murray and Groundhog Day, where I wake up every morning and do the same thing over and over again. So we've got a lot of experience in these kinds of wildfire litigations. And what we've learned is most of them are caused by utilities, but we're seeing more frequently poorly designed prescribed burns that get out of control given these tough weather conditions. And so what happened to you is not entirely unique. And so, we've got a lot of experience with respect to this. Joe's firm, as he mentioned, has prosecuted wildfire cases in the Texas Panhandle, over 1 million acres burned in West Texas since 2000. So we've got a lot of experience in this area. We've got a lot of big results in this area. And I won't take you through all the details. The only one that really counts is the top one. I was the lead negotiator for the largest wildfire settlement in history, $13.5 billion for the PG&E stuff that went into bankruptcy. That's important because in that litigation, we dealt with the federal government that was also making claims against PG&E, and they know who I am and I know who they are. We've got a lot of clients that we've represented, over 250,000 people. This is only relevant from the standpoint of we know how to set up the computer systems to represent a lot of people at once and how to communicate with a lot of people at once. And there's good and bad to that. The bad is we don't want anybody dropping through the cracks, but the good is you get enormous economies of scale. And I'll explain that here in a minute. So why is the PG&E experience important? Well, because the federal government knows who we are. We had more clients out there than any other lawyer. We represented the largest group of the victims claimants when it went into bankruptcy. As a result, I was asked to negotiate the deal with the PG&E folks, and I did. Ultimately, we reached a deal with PG&E and set up the largest trust in history in wildfire litigation, $13.5 billion. And so some of my colleagues who are involved in this fire, good friend Jerry Singleton, gave me credit for getting it across the finish line, did the negotiations, but it was a team effort. We were all out there, but I was proud to be a key part of the deal. And so why does that matter? Well, the government will know who we are. And so now we've got a job of, we've got to prove not only that they were at fault, but that they caused certain damage to each of you. And so we have very good communication systems to communicate with our clients. I really like doing in-person town hall meetings. Our first one out here was in April. And on that week, this is a good example of what my week looked like, because I was doing town halls in different fires, talking to my clients face-to-face, up and down California, New Mexico, Oregon, and the like. And in that particular week, we also deposed the chief executive officer of a big utility company. Because of these successes, we've got access to large amounts of capital. I've got relationships with New York bankers that give me lines of credit that allow me to invest tens of millions of dollars if necessary in these cases. And that's important because most of our clients, we work off of what's called a contingency fee, where we put up the money. We hire all the experts to do what we need to do to make the claim successful, and then we keep a percentage of what we recover on your behalf. Importantly, a lot of you have insurance. That's a private contractual relationship between you and your insurance company. You pay good premium dollars for the insurance companies to cover your losses on this, and we don't take a fee off of that. But what you're going to find out is most of you are tragically underinsured. And I don't say that to be critical. It's just the bottom line is most of us buy homeowners insurance because our mortgage company makes us. And we don't really pay attention to what's in there. Well, the insurance companies have lots of little gremlins in there. Some of them only pay you the value of the property the day before the fire, not the cost to replace it, which is about 40% higher. A lot of them have artificial caps in terms of contents. So you may have $500,000 or $600,000 of contents in your home, but you've got some contractual limitation that says they're only going to pay you for $200,000. My job is to go get you the difference. A lot of these homeowners policies don't cover the cost of replacing trees and all the outdoor losses that you sustain. So we'll go get you that different as well. We hire the best experts. This is a guy named Mike Schultz, who is kind of the author of the Bible on how to do a fire investigation. When we have disputes with defendants about how the fire started, Mike comes in and helps us establish that. I don't think we've got a big dispute here, so Mike will be involved, but we also hire damages experts For timber losses, we hire a group out of Wyoming called Western Wildfire Consultants. For arborist losses, my friend John Brown is on the line right now, and he's going to be out here constantly for the next several months, and I'll let him talk to you here in a minute. As Joe mentioned, in this particular fire, there are three options. One is called an FTCA lawsuit. That is a lawsuit under the Federal Tort Claims Act, but that is fraught with peril because of sovereign immunity defenses that I'll talk to you about in a little more detail. The best way I could describe it is sovereign immunity prevents claims from being successful, almost like water can put out a fire. Sovereign immunity is a tough thing to get around. And the reason is that courts have held that the United States Forest Service is immune. This is a backfire case called Green versus US. There are prescribed burn cases that say the same thing. But what we've been able to do with our research is to differentiate claims that have been thrown out of court when you're complaining about what the policy was versus complaints that the policy was in writing and you didn't follow it. And so we think that there's an avenue, although I won't lie to you, the case law is not great. This is why we're going for option number 2, and I'm working hard on this politically, and that is the United States government can waive sovereign immunity by law and allow you to file administrative claims. This is the so-called Hermits Peak Fire Assistance Act of 2022. Now, to your great good fortune, the 2 U.S. senators in New Mexico, Martin Heinrich and Ben Ray Lujan, are effective senators, as are the Congress people out here. But the reason I care about it is I do a lot of politics in Washington, and you see it's kind of all broken and very partisan. Heinrich and Lujan are considered kind of good guys that know how to work across the aisle. I don't really care whether you're a Democrat or Republican, but the bottom line is that there are fringe elements on both sides that won't talk to each other and that just fire missiles at each other all the time. Heinrich and Lujan are not considered missile throwers, and so it's easier to get people from the other party to come across and do things that are helpful. And so they immediately filed the Hermits Peak Fire Assistance Act, and we're hopeful that that will be voted out of the Senate sometime in the next 3 months, and I'll explain that a little bit more. So the bottom line is that this bill sets up a federal compensation fund to pay for your damages if it's passed. Importantly, the president is behind the bill. He's already, as a matter of executive order, announced that FEMA will cover 100% of the wildfire recovery costs. And when he announced that, he said this is a bridge until the Congress passes the Hermits Creek Fire Assistance Act. When you go to the content of the bill, and we've studied it carefully, it has already passed the House, and now it's passed twice, and I'll explain why that's necessary. And it's also at the same time that the Defense Authorization Appropriation Act of 2022 has been passed. And what we're trying to do is to get the two merged into each other. You may have heard this week about something called the PACT Act. And this is an act to provide medical benefits for service people. There is a subpart of that bill called the Camp Lejeune Water Pollution Act of 2022 that deals with a particular water pollution mess in South Carolina at one base. We got those two merged, and the only reason that one's going to pass is because it's been attached to the other. The same procedure is being worked on here, and that is that the Hermits Peak Fire Assistance Act, we're going to try to put it into the Defense Authorization Act of 2022, which we know will pass. So if it goes in, injured persons under the act include all of you individually if your property was affected. It also includes counties and cities, and we've talked to the city of Las Vegas and the counties involved that have suffered injury resulting from this fire. By the way, under the act, even though it says the Hermits Peak Fire, it's defined as one or the other or both because they merged. The kinds of losses that can be recovered under the act are loss of property, business loss, financial loss, and any other damages that the FEMA administrator determines to be appropriate. This is important because of my experience with the Fire Victims Trust out in California, where that trustee has the same language in there, and there's certain kinds of compensation that the Fire Victims Trust has agreed to pay for that aren't in these big three. And you've got all sorts of episodic type damages, about temporary housing costs, loss of enjoyment of property and the like, that we will advocate with the FEMA administrator should be covered by this act as well. So the damages that we know will be allowed if the act passes is property loss not covered by insurance. The government's not going to pay you for something that the insurance companies have already paid for. Decrease in the value of your property. And newsflash, the value of your property just went way down. I know this area well. I've been driving from Texas to Angel Fire to go ski since I was 8 years old. I've been on the road between Las Vegas and Angel Fire 100 times, and I know how pretty it is. And it's the prettiest part of New Mexico, if you ask me. And it's not as pretty today as it was 4 months ago. That leads to a decrease in property value. There's damage to infrastructure, roads that need to be done, plumbing, all sorts of infrastructure has got to be rebuilt. Importantly, and very importantly, the bill covers timber, agriculture, and hunting losses, and most importantly, reforestation or revegetation, the cost of replacing the trees. And then again, the other. So this is pretty comprehensive to cover all of the losses. And so what we're going to do is take the expertise that Watts Guerra has gained in representing 16,000 people in California. We know how to do the work to prep your damages one by one by one by one, and I'll take you through how we do that here in a second. Importantly, whatever you've been paid by insurance is an offset. You're not going to get paid twice, so continue to work hard to get your damages paid in full by your insurance company, and we'll work on what's left. And then lastly, this bill has an election of remedies provision that says, hey, you can either go into this act or you can file a Federal Tort Claims Act through civil litigation. My advice is if this bill passed, we go under the bill, because you don't have the defenses that exist under the Federal Tort Claims Act or civil litigation. But there's the election of remedy language. And what we're going to do as to the people who choose us as their lawyers is we're going to get your damages worked up between now and September, when we think this bill will pass, so that we'll be ready to go. We'll submit claims under the act unless you instruct us otherwise. And if not, we'll file Federal Tort Claims Act, and we'll do the battle as to whether discretionary function immunity applies, which I believe it does. Importantly, disputed claims can be arbitrated. So there's a dispute resolution provision in here. So that's functionally what we're doing. And I'll open it up for questions, but let me turn off the PowerPoint and just take you to, you're going to see a guy who's got a white mustache and a red shirt on. That is John Brown. John is a guy who has literally moved to California on my behalf, or on behalf of my clients more specifically, on multiple occasions. When I get involved in one of these fires, we set up shop. We end up representing the most people in almost every one of these fires because of our experience. And then we've got work to do. So functionally, there are four kinds of work that we need to do. First, to the extent that you were present or in what's called the zone of danger, and you took photographs or videos of the fire as you escaped from it, I need those. We run a paperless office, but we can download all of that through Hightail or through other file transfer deals, and that shows proof that you were there. Now, a lot of you guys are from Texas. You weren't there. This is second homes, and so we'll have more economic damages. The second category of damage is, of course, the lost value of the property or the cost to replace it. We've got experts in the terms of real estate agents that'll show what the sales price was versus what it is since the fire. You sustain massive damages from the standpoint of loss of value. If your homes were burned down, you got to rebuild them. Unfortunately, it's going to cost you about 40% more than the home was worth to get that done. And the reason is that it's law of supply and demand. There's only 3 or 4 contractors out here, and all of a sudden they've got to rebuild a bunch of houses. So supply and demand says the price is going to go up, on top of all of the supply chain and fundamental raw material shortages that exist in this country right now with inflation. So everything's going to be more expensive. So we'll have experts that prove up those costs for you one by one by one by one. And then the third area of damages is everything that was inside your house, your so-called interior contents. Mr. Blackledge, I'm looking at you on a screen, and behind you, I see a bunch of books, and I see some stuff on the wall. That would be an example. If the house burned down, we would, in effect, go room by room and try to figure out everything that was in it. And then functionally, we have insurance adjusters that are so-called contents experts that know how to price every single widget. And so I've developed a proprietary software that takes you room by room through your property. It's kind of a prompt, if you will. And let me use the kitchen for an example. We'll show you pictures of every different kind of blender that exists, every different kind of waffle iron that exists, every different kind of dishwasher that exists. And it'll help you remember what kind you had in there. And then we type that into the database, and then our pricers go to, in effect, eBay. It's not eBay, but it's the equivalent of it, and figure out what it costs to buy that. And then we build an Excel line by line by line by line. You could have 1,200, 1,500 lines in your interior contents. I call that taking you to contents college. This is important to do because it adds up to several $100,000 of money that you may not be getting from your insurance companies. And then the third part is we go outside your home. And that's where John Brown comes in. And we don't think about how expensive it is to redo landscaping, driveways, hedges, outdoor tool sheds, pools, hot tubs, decks. John does all that. And he does that using some pretty good technology. Big Brother is watching you in the form of Google Earth. Google Earth replaces its images every 6 months. And so that fire footprint, John knows how to pull down all those images from up top. But the other thing that we're going to want from you is any photographs that you have that were taken at your property. You take them around birthday or vacation or whatever, and all the smiles of the kids and the grandkids and the like. But we're looking behind the smiles to look at what was on Mr. Blackledge's wall behind him, or Susan, what kind of TV screen that's over your right shoulder behind you, or that beautiful mirror that's behind your left shoulder. And we get all that added up through the pictures as prompts. So we get all of that, whether indoor or outdoor. John needs the outdoor stuff, and then he builds it line by line by line by line, and does an Excel file, and in effect adds it all up, and it's several $100,000. So John, why don't you take a second and just explain for them who you are, what your background is, and what you'll be doing on their behalf over the next several months. And make sure you non-mute yourself.
Hey, good morning, everyone. My name's John Brown. I'll give you a little background. I've been working with trees since I was 5 years old. As a teenager, I planted 13,000 Norway spruce and red pine on our farm. And I went to college at East Texas State University and got a bachelor's degree, Texas A&M for a master's, North Carolina State for a PhD, and I postdoced at Duke University. I've been in business for 29 years, since July of 1993. I really enjoy what I do. Here I am. I retired in 2015, but Michael has kept me busy on these fires, and I've worked thousands of fire properties in California, up in Oregon. I was on the Bobcat Fire in the Mojave Desert last year for about 4 months or more, counting Joshua trees. I love what I do, and I treat every property the same. My job is to evaluate your trees. And if you noticed earlier about the act, it talks about reforestation and revegetation. Well, that's replacement cost. So I value your tree to be replaced at a cost, and also that tree to be maintained for 3 years. That not you, but someone will come out there and maintain those trees that have been replanted. And then I give a loss of enjoyment. I mean, those trees are beautiful. You love those trees, and they play an important part. in your life and in your family's life. So there's a loss of enjoyment. And I calculate all of those factors. And then sometimes your trees aren't totally dead. There's partial damage, and then I evaluate the partial damage for those trees. Well, there's shrubs and there's perennials, and there's landscape beds. Day before yesterday, I was looking at a little property, and this lady had made a waterfall, stone by stone by stone. I take in consideration waterfalls and other landscape features that you've developed. Things on the outside, decks, your hot tubs, swimming pools. A lot of times the fire is so hot that it melts the plumbing that's in and around your pool, and electrical underground wires, and then fences, all kinds of fences, wooden fences, wire fences, cedar, redwood, pine, and each one has a different value. So I measure those either when I'm at your property, or I use Google Earth, like Michael said, and I can measure distances to get fencing, etc. I also take into consideration your house. If you think about your house and it burnt down, you have a lot of chemical components. You have plastics, you have metals, and when it burns, you have toxins that are in the soil or where the house was, or where the footprint is. And then I take a boundary of 5 foot around the house and remediate that to make sure that those toxins are removed. And then there's sites, especially now, I mean, with the rains, if you saw yesterday, there were huge, I know you're in Texas, but there were huge rains here yesterday. The roads were closed and there were flash floods, and properties are silted. I've been on properties completely covered with silt. So that has to be remediated. I take all those into consideration. I put them into a program I've developed, and you'll get a copy of that, and you'll look at it. And if you see something that's off, we'll consider that and make corrections. So that's basically what I do. Turn it back to you, Michael.
All right. Thank you, John. Okay. So what are our timing issues? Here's the challenge. The Federal Tort Claims Act has a notice provision that says we need to give notice within 180 days of the event. I try to be very conservative, and that is that just because I'm conservative on deadlines, I'm going to assume the event is day one of the fire. And as you know, it lasted for well over a month. So we've got calendared in our office the date that is 6 months from the date of the fire. We are, for 2 reasons, out here working hard to get the word out. Number one, we don't want anybody to miss that deadline to the extent that it's necessary. In other words, if the bill doesn't pass, then all we have is the Federal Tort Claims Act. If the bill passes, then we'll have more time, but we can't assume it's going to pass. So we are accepting representation from people now. We've got our experts out here now, because in the notice of claim that you have to do within 180 days of the event, you have to state the amount of your claim. And the law is very clear under the Federal Tort Claims Act. There's something called a Form 95. Whatever dollar amount we put in that notice of claim, it's an all-time cap on what you can recover from the government. So I want us to be somewhat cognizant of what the damages actually are and not guess. So we're trying to front load the damages work during the months of June, July, August, September, so that we've got a real good idea of what that number should be, so that it's at least in the ballpark to get you the damages that you're entitled to. Now, full disclosure, it is my belief that this bill will pass. If the bill passes, then you'll have more time. But I've learned in watching the Congress that people who think that they can predict what's going to pass and what can't get disappointed a long time. But I am in discussions with people in Washington about what's going on a daily basis. The Wildfires bill passed the House again yesterday. They've now passed it twice. They've also passed the National Defense Authorization Act bill and the Wildfire bill. They're going to try to get the Senate National Defense Authorization bill to include what we're talking about here. That's the strategy. But at the same time, I cannot promise you that strategy will be successful. You may have read that there was a deal done 2 days ago or 3 days ago between Senator Manchin and Senator Schumer with respect to some environmental stuff and some spending bills and some taxes. That agreement uses a vehicle called reconciliation. In the United States Senate, every bill requires 60 senators to allow it to go to debate. It's a cloture vote. There's one exception. One time a year, you can slip stuff into a budgetary issue called reconciliation. And that's the way that people stuff their project in and can pass with 50 votes. Whoever's in the minority party, and right now it's a 50-50 Senate, but the Democrats have the vice presidency, so they're the majority party and the Republicans are the minority party for now. They always get pissed off when anybody uses reconciliation and they throw the brakes on the Senate to show their displeasure. That's what the Republicans did yesterday. They voted down the PACT Act, which the week before they had voted for 84-16. So everything's frozen up a little bit. I think all that'll get unfrozen. But it's real hard to go an entire year without passing the National Defense Authorization Act. But, you know, if senators want to freeze it up, they can prevent your bill from being added to the National Defense Authorization Act, which is why I can't predict for you that it will definitely pass. I think it will. So if something happened and somebody threw the brakes on that, then we have to go back to the Federal Tort Claims Act, and we have to have our notices ready by 6 months from the date of the start of the fire. So that's why we're working hard. So, Joe, that's what I've got to say, and I'd be happy to answer any questions. But I think what we wanted to do is to kick it over to Brian, who frankly has spent more time digging into the U.S. Forest Service report, and will explain to you why it is that we think, even if the bill doesn't pass, that we have an avenue around the sovereign immunity with the discretionary function exemption. So go ahead, Brian.
Well, first, I'm going to introduce Brian in just a second. He's sitting right outside the phone booth here, and so we're going to swap places. But kind of as an introduction for Brian, I wanted to touch a little bit more on what we view, why we view these cases the way we do, and then Brian is going to elaborate on that. Like we said, we think there's 3 potential routes to recovery: the Federal Tort Claims Act, this bill, and then a takings claim. Now, frankly, and I know there's lots of lawyers out talking to people about their take on this, but our view is that this really, he's getting pictures of me here in the phone booth. Our view is that this really is not a takings claim, and there's a reason for that. There is a case out there called Thune versus the United States. Of course, there's lots of cases out there, and there is a line of cases, of flooding cases, that if you analogize the flooding cases to a prescribed burn case, there's certainly an argument that a prescribed burn might fall within a takings claim. If you have a takings claim, it's a separate kind of process. It's got its own rules. It's got its own damages, et cetera. It's also got its own court, and it's a court, the Federal Court of Claims in Washington, D.C. But this Thune case, it was a prescribed burn case. And in that, prescribed burn got out of control, ended up burning up a lot of property belonging to a hunting outfitter. And the hunting outfitter brought it as a takings claim. But the court in that case issued an opinion that said, no, this is not a takings claim. You're alleging that the federal government did something wrong to cause this fire to go out of control and destroy your property. In the language of the court, they said that sounds in tort. And so this claim is a Tort Claims Act claim. So for that reason, we're not convinced that it's a takings claim, but we're not dismissing that either. Now, so that brings us really to the two avenues we think are going to be the ones that need to be used. Brian is about to talk about the challenge with the Federal Tort Claims Act being the discretionary function, but how, if this bill doesn't pass, how we still think we can probably fit this in to get around the Tort Claims Act. But hopefully this bill will pass, because for a lot of reasons, we're convinced that it would be the best for most of you. And we also, before I turn it over to Brian, I just want to tell you that we're telling everybody that as far as filing a claim or bringing a suit, and that's different than notice of claim, but filing a claim or bringing a suit, we're telling people don't do that yet, because there's a provision in the bill called election of remedies. And it says that if you, for example, file a suit under the Federal Tort Claims Act in district court, you have forever elected your remedy, and you can never go back to seek compensation under the fund, which may be easier, you may be able to recover more damages that way. So we need to wait and see what we think is going to happen with this particular bill, because we don't want people electing their remedies. Now, the notice of claim that Michael talked about, that's a different thing. That's not filing a claim or bringing a suit. And that's still something that has to be done in order to file a claim or bring a suit under the Tort Claims Act. But with that, I'm going to open the door here and turn it over to Brian and let him get in the phone booth.
Right, you're up.
Here comes Superman.
Superman. I don't know. Well, we're trying to play, get away from all the feedback noise. So I got to move. I've been outside. I've been inside. Now I'm in a phone booth. So, all right. Hey, Joe. Yes, sir. Did something. All right, I'm back. Sorry. I pushed something and I got the screen away. All right, my name is Brian Farabough. I'm partners with Joe Lovell. I think mainly, and I'm going to be short because we got another meeting coming up, but what at least what I've dug into, I don't know who has read it, and I can ask for a show of hands, but I won't see everybody on this screen. But they released a review of the fire plan and its what happened with the wildfire, the Forest Service in June. And if you haven't had a chance to read it, go find it. It's available to the public. We've asked for the burn plan itself and haven't received it from our Freedom of Information Act request. That's important to know what they were supposed to do as part of this controlled burn. But from the review that they conducted afterwards, we see a lot of the information that we would find from the burn plan. And so in one thing that they do, and if you've read the news about it, there are a lot of these bad things that occurred. I say bad things, missteps, misallocation of resources. You have old equipment that is being used instead of new equipment that is available for getting the weather information to determine if there was enough moisture to be within the range of when a controlled burn could be started. So they looked at this old equipment that wasn't as accurate, and they say in the review, well, the conditions were drier than we knew because we were using this old equipment. And they say we got to update our equipment. Also had a burn plan that was put in place in 2019, approved in 2020, and then successively delayed all the way until April of 2022 because of COVID, because of Mexican spotted owl regulations, that they were not allowing controlled burns to burn through areas of the Mexican spotted owls like breeding grounds. And they were under intense pressure, the U.S. Forest Service, to get these prescribed burns moving forward. And so we call it, you saw maybe in slides earlier, the blind rush. They can only burn between September and May typically. And so they had April of this year in which they had some potential to start this controlled burn and not be delaying it another year. Keep in mind, this is a plan from 2019 that has not been updated for any year since. So it wasn't updated for the drought conditions in 21 or 22, and they just kept rubber stamping it forward. So we get to this point, they say on April 5th, I mean, at the end of March, they say, we're going to look in April to start this fire. On April 4th and 5th, in the area where the controlled burn occurred, it was a red flag warning day, or both days, red flag warning days. But looking at the old equipment that they had, they say on April 5th, hey, we're going to start this tomorrow because it looks like our best chance. And they do. And they go in April 6th, 11:34. I mean, before that, they've been doing all the work they need to do, but we see that they're going through the process they have to go through. They do a test burn to see if the conditions on the ground when the fire is started are within what they believe the parameters should be. They say it's successful, and they start with two teams, an Alpha and a Bravo team, doing the ignitions for this controlled burn that just 4.5 hours later is going to be deemed an out of control wildfire. And so they start with these two teams doing ignitions. Everything, at least from our review, looks pretty good up to that point. But what we see, and you saw a slide about this earlier, is at about 1351, as it's reported in the report, they have one Bravo team burn or firing boss trainee or firing trainee. So this is a guy that's training to be in control of ignition. It's not even a person that's been appointed or put in that position, hired for that position. This is a trainee, Bravo firing trainee, says, I want to take fire to the toe of this slope that the Bravo team was on. And the fire boss said, okay, you can take the fire to the toe and then you hang it up for the evening. And then you see just beyond that this firing trainee comes back unannounced, meaning he didn't say, I'm going to bring it back. He didn't say he was going to burn another line. I'm coming back unannounced. And from that point, you have the first major spot fire. So something that went out of control beyond the plan. That was a fire line that was not within the plan. It was not approved. And so here we see, as opposed to what would be discretionary function, where they're allocating resources or making decisions about personnel and people or equipment. So we used old equipment versus new equipment. We put people in this location as opposed to another location. And that's discretionary function. A lot of that's what the report talks about, because it's actually designed to protect the government. It's not designed to benefit the people that were injured. But at the same time, in the timeline itself, they reveal deviations from the plan. And there was a slide earlier about Cerro Grande. New Mexico has fought this for a long time. They've had out of control wildfires in New Mexico for a long time that were caused by prescribed burns. After the Cerro Grande fire in 2000, the U.S. Forest Service said, from this point forward, because we don't want to let these things happen again, we're going to have burn plans and we're going to follow them to a T. And so that's where we see this deviation, where we see the foothold we have to make a tort claim and get around discretionary function, because they can't deviate from their burn plan. And when they burn lines that start spot fires that weren't approved, that didn't go over the radio, that a burn boss or firing boss didn't say, you can do this, that's a deviation from the plan. And we don't see just the one. that one is the first domino. It's tipped when they burn back up the slope without any authorization, without being announced, without going over the radio, and without following the plan. And they start that spot fire. From that point, they have to pull team members from Alpha Team over to fight it. And from that point forward, when you read the timeline, they're chasing spots. Now, it looks like it's better at the beginning, but within 2 hours, they have that same Bravo firing trainee burn another line he wasn't supposed to, or he or she, it could be either. That report doesn't say, but that firing trainee went back down to the toe of the slope, says on the radio, hey, we're going to take some more fire down. This is during a time period when the firing boss had said a hold on all ignitions. He said, well, we're going to go down and burn again, sent igniters down. They get back on the radio, say, don't do that. We're still holding ignition. And the firing trainee says, oh, it's too late. We already sent them. And so they're already burning again. And within 45 minutes of that second unannounced, unauthorized burn, it's declared a wildfire. And they have to pull back because they don't have the resources to fight it. That type of deviation from process, procedure, I mean, that's not discretion. You don't have the discretion to burn lines that are not part of the plan and approved by those that are above the firing trainee. In fact, I mean, it's kind of like a ship. I mean, everybody has to be in communication and be following those above them. And I've talked to people that I know that are volunteer firefighters that have been participants in controlled burns, and they say you don't burn anything until somebody over the radio says you can. And so when they're saying unannounced or unauthorized burnings occurring in this timeline, that's a very clear indication of something that is not following the plan to the T, that is not discretionary function. That is absolutely, Joe's trying to show me a message. I can't read it.
What's your message?
Okay. And so anyways, I'm being told that we need to end it there, but we think we have a very good case for a tort claim that gets around discretionary function because of what we see in this wildfire review from June. And we're hopeful that we get to go with this compensation fund path because we think that's better for everybody. And I think Michael has covered that well in his part of the presentation. But if we have to fall back on a tort claim, we feel very comfortable with it. And we think there's a really good basis for proceeding with it.
Thanks. Let me open it up for any questions, but let me just start off with the ones that have been typed in. Susan asked, what about those of us whose property was still undeveloped? That was a lot of trees. Yep. Will you be able to figure out how many and what type of trees were actually there from the Google Earth images? I unfortunately have no pictures of my property. Susan, what we do there is we hire timber experts who will go out, and either John or these Western Wildfire guys, and functionally they walk the property and they count the trees and the size of them like that, and they try to figure out what the dimensions are, both from the standpoint of height and width, and then they count. And then you can figure out what the replacement of those trees is. Now, it's impossible to replace some of these 60, 70-foot pine trees and big tall trees, but John knows what it costs to replant an 18-foot tree that's going to become a 60-foot tree. And so, yes, we go out and do it one by one by one by one and keep going until we've added the ball up. It's very systematic. So Landon asked the question, if they pass the act and we file our own claim with well-documented pictures of the property before and after the fire with all the loss, how much less of a settlement will we receive if we go with your firm versus filing on our own through the Recovery Act should it pass? Okay, so there's two things that I would tell you about that. Importantly, when the Recovery Act said other damages, one of the elements of damage that the Fire Victims Trust is paying is attorney's fees. And we'll make the argument that because, in effect, the government took your property, that the administrator of FEMA should compensate for your attorney's fees as well. Can I promise that'll happen? No. So then, to answer your question directly, Landon, the question is whether or not you believe, and again, it depends on your particular property, whether you can blackboard the damages to the same extent of the people that I would hire on your behalf could. And these experts aren't free. They're worth it, and they know what they're doing. They've got a lot of experience. So I'll leave that to you. But you'll certainly have the ability to do this by yourself if you want to try. And it, depending on your expertise, it may be something you can do. I don't know. Second question. The USDA has a program available to help with wildfire cleanup, including rebuilding fences, hazardous waste cleanup, soil remediation, debris removal, cleanup of the house footprint, burnt equipment removal, rebuilding of fences, and several other things at a 75-25% split for those costs due to the wildfire. Is applying to this program, which we already did but haven't had our assessment done yet, considering electing our remedy. Should we cancel that claim? The answer is no, that's not an election of remedy. And the answer is no, you shouldn't cancel that claim. But Joe's already done some good work for you, whether you're our client or not. There was a version of one of the state programs that had a release of claims against third parties, and he raised hell about it, and they pulled that down. So just make sure you don't sign a release of anything. They may say, hey, if we're going to be out there rebuilding your fence, we don't want to be sued for it. I just don't want you to release the U.S. Forest Service. Okay, so make certain that you don't do that.
Michael, could I touch on that just a second?
Sure, go ahead.
Michael is right, except a fine point there when he says it's the state of New Mexico, their debris removal program and their release language. Also, it was broad enough to where a court, if it chose to, could construe that release language to release the federal government for any liability it has on this. And so we did. We started complaining to the state of New Mexico, and frankly, we've been very frustrated. Now, the response from the state of New Mexico has been, hey, we're not intending to release any claims people may have, so people shouldn't worry about it. Our response was, okay, New Mexico, why don't you change the language then? Ultimately, we had a conversation with their attorney yesterday afternoon, and that organization within the state of New Mexico, they think their press release saying that they're not intending to release anybody or release claims against the federal government, they think that's good enough, and they're not going to change the language of the release. I just want everybody to know that for that particular program, I don't know that it would constitute a release of the federal government for those claims. And I can, as a lawyer, I can see lots of ways to address that should the federal government try to say they are released. But you need to know that that is a calculated risk. Now, if the bill passes, that takes care of all of that anyway, because if this bill passes in the form it's in right now, the federal government is admitting liability anyway. So that release language that the state of New Mexico has doesn't matter. In any event, that's where you're at. Probably, I assume you're going to be okay on claims against the federal government, even if you do participate in New Mexico's hazardous debris removal. But just understand there is a calculated risk there that the feds could say you release them. Thank you, Michael. Go ahead.
Okay. So the next one is anyone in the firm a registered lobbyist, or have you hired a registered lobbyist regarding this event? So what we do there is I fund an organization that is functionally a lobbying organization. It's called the American Association for Justice. It's the national trial lawyers organization where trial lawyers like me, there's hundreds of thousands of us, but we all fund a common effort to lobby in Washington. We have an executive director named Linda Lipson, who is outstanding. That text I showed you is my correspondence with her. She's the tip of the spear on this. But if you have good relationships, those of you in Texas with Senator Cornyn or Senator Cruz, that's a smart call to make. If you have good relations with Senator Heinrich or Senator Lujan, couldn't hurt to say, attaboy, keep working on it. We're counting on you, or something like that. But we feel like on the lobbying angle, we've got it done pretty well. Not to say that if you have a relationship with a Republican senator that you shouldn't exercise that and say how important this is. Okay, so the next one says, well, Kathy Wade has her hand raised. Kathy, do you have a question? Oh, I see the little hand. Okay, yeah. You're still muted, ma'am. You know, while she's getting that unmuted, it occurred to me that 2 years ago, none of us even knew what Zoom was, and I still haven't learned the hand raise. There you are, Kathy. Go ahead,
Okay.
ma'am.
I see one exception potentially. I just saw 1 or 2 paragraphs that you put up on the about the bill that is currently in Congress.
Yes, ma'am.
And it says New Mexico residents. It doesn't, what about the rest of us who are not legally residents of New Mexico, but have lost hundreds of thousands of dollars worth of stuff?
I'm not exactly sure the language that you saw
Yeah.
that limited it to New Mexico. Let me see if I can pull that up and maybe you can find it. Let's see here. Joe, do you know what she's talking about?
It was the bill filed by the New Mexico
Yeah.
Congressman, and then it had New Mexico residents that I saw.
Well, I'm not exactly sure what you saw, but I am looking at the bill that has passed out of the House of Representatives that's pending before the Senate. And it defines an injured person who is entitled to compensation as an individual regardless of the citizenship or alien status of the individual, or B, an Indian tribe, corporation, tribal corporation, partnership, company, association, county, township, city, state, school district, or other non-federal entity, including a legal representative that suffered injury resulting from the Hermits Peak Fire, Hermits Peak Calf Canyon Fire. So it's not limited to New Mexico residents. It's wide open.
I think
Okay.
that's right. And I just showed you the language. So I think we're good on that.
Okay.
Okay. So Mike asked a question. I've seen the private property Excel spreadsheet, but not a form for the big ticket items. Athens Park model, manufactured home, shed, an extensive deck, and the like. So John, you want to take that and explain how we're going to get all those in?
We cover all your sheds, garages, buildings, your fencing. Like some people have large ranches with barbed wire fencing. All that's covered. Even though your fencing looks good, when it's exposed to high heat, it destroys the covering. In 2-3 years, the fence will rust. So I take that into consideration. Swimming pools, I mentioned, but I cover everything outside. If it's outside, I get it. Does that answer your question?
Okay. The next question says, would the current version of the legislation compensate property owners who suffered no direct physical damage, but have suffered a significant loss of value? Apart from the legislation, how can property owners ensure that their options for a tort claim and takings claim are preserved in case one avenue turns out to be successful and the other one does not? So, and then can you explain the contingent fee? Let me do them. There's 3 questions there. Let me do them one by one. So if your property wasn't burned, but you're in an area that was substantially burned, does it affect the value of your property? And the answer is obviously yes. No offense, but nobody wants to buy a property that's looking at, a burned up vista. If you look at the act, one of the components under the loss of property is a decrease in the value of real property. And so I've been to neighborhoods where it's episodic. Some houses are burned, some are not, but the houses that remain, nobody's going to want to buy because of everything around it. So I think the answer there is yes, you'd have that claim. Second question, apart from legislation, how can property owners ensure that their options for a tort claim and or a takings claim are preserved in case one avenue turns out to be successful and the other does not? Let me address the issue of takings for a second. I know that there's another law firm out here that says these are takings cases. But I don't like talking down about other firms because I'm sure they're fine. I disagree with them. I've done research. I don't believe that under the federal circuit law that a takings claim will be successful here. In fact, there's case law directly opposite of that. That's my opinion. Different lawyers may have different opinions. But as to the other two options, and that is a tort claim under the Federal Tort Claims Act or under this bill. So because it's going to get attached or not to the Federal Defense Authorization Act, we're going to know the answer before your deadline to file the notice under the Federal Tort Claims Act. Okay. We may, as a matter of course, go ahead and send all the notices under the Federal Tort Claims Act and then never file suit. We're not sure yet, but we want to be ready. So the way you get prepared for this is allow us to do the damages work we need to do so that we've got a good number if we're forced to file the notice of claim in order to preserve your rights. My hope is that the Hermits Peak Fire Assistance Act will be passed before the 6 months of the date of the fire. Can't promise it though. That's why we're doing the work now. Okay.
Michael, if I could, we got some more questions, but before that, if all of you would look at your chat feature, what we're just trying to do is make sure we got everybody's name and their contact information, whether that's phone or email. And you can do that if you'll just go to chat. You will see either Hannah or Melissa on that chat, and you can just fill it in there, and that's all we need. Now, having said that, Carol Compton has been trying to ask a question for a while. So, Ms. Compton, go ahead.
And you're muted, Carol, so you need to unmute yourself. There you go.
Question deals for timeline. You said the end of September. Do we need, I've sent in pictures, and I wonder if I need to send more pictures so you can see inside the house, outside the house, trees,
Yes, ma'am. You send us all the pictures you can of the inside and the outside of the house. They're very helpful.
Okay, what about, we've already gotten our insurance money, and
Good.
it just strictly paid for what it was worth when we built the cabin.
Yes, sir.
But
Yes,
we
ma'am.
did send a list of all the inside of the cabin and what his estimate was as far as that. Do you need a copy of that?
Yeah, I'd like any correspondence you have back and forth from the insurance companies, because it serves as a prompt. And you know, the good news is that even if you've already sent in a list to the insurance company and they paid you, and then 2 months from now you think of a bunch of stuff you forgot, we'll go get you the stuff that you forgot, or help you supplement the claim to the insurance company. Okay.
Okay. So we need to get all into your office.
Yes, ma'am. Linda, you got your hand up. Go ahead. You need to unmute yourself, and then we'll answer your question.
Yes, sir. We've received our insurance claim, and we know that we had a lot more valuable property. Although we did not list that on our sheet that we turned in, we did go over what our limits were.
Yeah.
Is that going to impede us in any way going forward?
No,
Okay.
The fact that you don't get full damages out of your insurance company is not going to limit you. But look, you pay the premium. So if they short sheeted you, keep pressing them.
Okay. Well, I just mean, I don't think there's any way we could do that because we reached their limits. We've already called them. I wouldn't know how to. Maybe I should talk to you. But what I meant was we didn't continue listing any more things, and we know they didn't value trees or the deck the way it should have been valued, and we had only owned it since October.
Right.
I mean,
we'll go through and redo all that, and make sure that we get you everything, whether the insurance company paid you for it or not.
Or whatever we listed doesn't make a big difference then. We can still, because I guess your spreadsheet, we should just keep adding to it what we know we didn't.
Absolutely.
Okay.
Absolutely.
Right.
It doesn't matter, and really what happened to you, Linda, is very typical. And that is because most insurance policies have that cap. These guys are doing kind of back of the napkin stuff. They look at the square footage, they come up with a value of the house, and then they take a percentage of it and pay you in contents. It's very back of the napkin. What we do is more line by line by line by line to make sure we get everything that you have. Okay. We've got time for one more question, and then we've got to jump to this next meeting that starts at 10:30. Does anybody else have a question? Okay, there was one other issue, and that is that George asks, I've used a public adjuster to file my claim. Will the government be responsible for paying the adjuster's fees? So that's a solid maybe, George. You remember the other damages, it's up to the FEMA administrator. They don't have to, but we'll certainly tell them that they ought to. And frankly, we've listed those kind of damages out in California as well. Okay. Hannah says, I understand the lawyers do not think a takings claim has merit, but what if a tort claim gets dismissed because of the immunities? Can owners then file a takings case? I don't see any reason why not. But again, our path right now is to try to get this bill passed so that you don't even have the risk of getting dismissed in a tort claim. But we're ready to go through that. But my view, and again, I may be wrong, but I think there's a case dead on point out of the federal circuit that says this takings deal is not going to work. I hope I'm wrong, but that's the way I read it. So I'm telling you where we are. Okay. With respect to the contingency fee, we don't take a fee on what you get from your insurance company. That's between you and your insurance company for premiums you paid. It's a 1/3 fee. The fact that Joe's firm and my firm are both involved, we split that. We don't charge you double. The expenses that we do, we're real good at monitoring. For example, we get economies of scale. John's down here doing all the properties at once, so we don't have travel costs back and forth for each of you. And usually those expenses run 2, 3, 4, 5%. So can't promise you what they are, but in an administrative claim, you're probably looking at 1/3 plus 2 to 5% of expenses is generally what it was out in California. And you don't owe that fee until we get you a recovery. That's why it's called contingent. But I'm not out here for my health. I'm out here because I believe in this. We studied the law very carefully before we decided to expend the resources, and we're going to open up an office out here after this bill passes so that we can do the job that we need to do for all of you. But the bottom line is we're confident that we'll be good to go. And our goal is to get you paid quickly through this administrative process so that we can put the money in your pocket that's needed to rebuild these homes and to get you back to where you should be. Okay, guys.
Real quick before we get off, one just clarification on what you're going to see in that employment agreement is the fee is 1/3 or the maximum amount allowed by law, whichever is less. And that's because some of these federal statutes or the federal bill may well end up capping fees at a certain level. We lawyers understand that. And so if the law says the maximum fee you can recover is 25%, then that's what it's going to be. But that's the language you'll see. And just last, we've got to go now to start this other meeting. But for those of you who have not yet given us your contact information, if you'd please stay on and get on the chat feature with Melissa and Hannah, give us your contact information. And that way we can keep you updated as these things develop. And we sure do appreciate everybody coming. Thank you very much. Do not hesitate to call or contact us with questions or concerns. And we hope to see you soon and look forward to working with you. Thanks.